All right, Robert, what happened today?
Well, so when my client was originally booked on these charges, they booked him on the wrong offense level. So they booked him on a second-degree felony, and it's actually a third-degree felony. So the judge had to magistrate him again, but we still have the same issue with clearly excessive and unconstitutional bonds. The bond schedule set by the district court judges for most third-degree felonies is $5,000, okay? And even with extenuating circumstances, bonds of $500,000 on two third-degree felonies is ridiculous. Coupled with a full house arrest and surrender of his passport, it really is just an attempt to coerce my client to cooperate and give a statement. And on top of that, the other part of the coercive nature is Sheriff Salazar is keeping this 65-year-old man in a holding cell. He's been in a holding cell the entire time he's been at the jail. He's a Seventh-day Adventist, and they adhere to the same dietary restrictions as Jews, but he's being fed a bologna sandwich every day. So he's not able to eat. He's kept in a holding cell with restrictions. He can't get access to a phone. He can't call family members. And it's my understanding from somebody at the jail that Joe Gonzales and Sheriff Salazar are doing this together as a means to try to coerce my client into cooperating. So obviously we have a bond reduction hearing set November 4th. But this is probably the most unconstitutional, egregious action I've seen in my 30 years of law practice. I have murder cases and capital murder cases with bonds that aren't this high. So clearly you can see there's a pattern of abuse of the process that's being carried out by the DA's office and the sheriff's office on this case.
Were you hoping today to get that reduced?
Well, the judge, I mean, it was a brand new magistration. The judge could have set the bond at anything he wanted. He could have set it at $5,000, not the $500,000, the ridiculous amount that was set by whatever magistrate set these bonds, and the magistrate set them based upon a request from the DA's office, right? In an attempt, because obviously they want to keep him in jail because they want to try to coerce him into cooperating.
And what is your client's state of mind? How's he doing?
Well, I mean, he's a 65-year-old man who's never been to jail before, right? Most people aren't going to handle that very well, particularly when you're in a holding cell. You can't call and talk to your family. You can't take a shower. You can't eat. You're being treated like crap. So I would describe it as not being very good based upon the abuse he's receiving at the jail, and I think instituted by the DA's office.
And you're hoping November 4th for more evidence to come out, and then the bond...
Well, no matter what evidence comes out, the bonds are clearly excessive. It's a third-degree felony charge of tampering with evidence and possession of a prohibited firearm. I mean, the majority of the time I have clients on these cases, they have $7,500 bonds, not $500,000, right? So the bonds are ridiculous, but they were put in place at the request of the DA's office. I would add probably in cahoots with the sheriff's office and law enforcement to try to coerce my client into cooperating.
Are they going to move him to a regular cell now, or?
Well, they should have moved him to a regular cell days ago. I don't see a good reason they haven't done it. He spent 4 days at the magistrate's office, which is also something I've never heard of. And I've never had a client housed in a holding cell for this long a period of time. So it's clearly I think it's intentional, and it's essentially trying to cook my client and incentivize him to cooperate.